opening statement with Ms. Rossi going first. And then the questions will have a 90-second, speakers will have a 90-second time to respond to questions. And then a 3-minute closing argument with Mr. Gascon going first. If the speakers, in fact, do not respond to a question, I may well ask them a second time to respond. We are taping, and we have a timekeeper. Bonnie, would you indicate the times? We have 1 minute, 30 seconds, and then you're supposed to stop. Okay. We also have over here question orders from the League of Women Voters. They will pull questions that are similar to each other together and hand them to me. I will then ask questions, hopefully taking all of the similar questions into account. We do not ask questions that constitute a personal attack or something that's highly inappropriate. So if you write a question like that, please don't expect it to be asked. Similar questions, like I said, will be combined, and if we have too many questions, which is entirely possible, because we're only going to go to 7:30 tonight, we will then have to cut off the questions. And it is the League's practice to keep the questions so that it will not be returned to those who are submitting. So with that in mind, we will start off with the opening statements by each of the candidates.
Good evening, everyone. My name is Rachel Rossi, and I'm running for LA County District Attorney as the first former public defender to ever run for this seat. But I am much more than that. I am running because I bring a perspective of the humanity of seeing the other side of the courtroom as a public defender, but I also bring the policy, the expertise, and the understanding of having worked in both the Senate and the House of Representatives on criminal justice reform legislation that became law. I'm running because we can talk about the fact that there's a 41% increase of our homeless population circling in and out of our jails. But when we talk about that data point, I think about my homeless client who I bought a purple dress for trial. And all she asked me was, at the end of the trial, can I keep that dress? We could talk about the racial disparities that if you are Black in LA County, you are 13 times more likely to be incarcerated. I'm running because when I hear that statistic, I think of my client, young Black, who was charged with possession of graffiti tools with the intent to commit graffiti. He held a marker. That was his crime. We can talk about the data that there are a need to understand and stand with our immigrant community in LA County. I think about my client who was charged with getting into a fight at a concert and was deported and ripped away from his 2-week-old baby. I'm running for this seat because I have the humanity of understanding the impact of the criminal justice system on people, on lives, on human beings, but I am also running as the candidate with the experience, the policy ideas, and the ideas for fresh, innovative, modern-driven reform today. So looking forward to speaking with you and answering your questions today. Thanks for having me.
Thank you for being here this morning, or this evening. You can tell how my days are blending together. I am running because I care about my community. I immigrated with my family to the LA area in the late 1960s. I'm a high school dropout, so I know what it's like actually coming through the rough part of town. Many of the kids that I grew up with, people that I know, are not around anymore. Many went to prisons and jails. I am running because I have seen the criminal justice system from one end to the other. As a young police officer with the LAPD, I walked many of the beats in neighborhoods very similar to the one that I grew up in. I got to hold mothers together when their sons were killed. I got to work with former gang members that were coming out of prison. I got to work and do intervention and mentoring programs for kids that grew up in neighborhoods very similar to the one that I grew up. And I got to see one generation after another generation of same families going to prison with no end in sight. I became involved in the criminal justice reform because I came to the conclusion that public safety and reform travel on the same lane. And not because of aspirational goals, but through personal experience, I have been able to show that actually when you implement thoughtful reforms, you can actually lower crime. And we have seen during nearly 8 years as a district attorney in San Francisco, how we lower violent crime at the same time that violent crime went up in LA County, about 30% and over 50% in the city of LA, while they were incarcerating at 4 times the rate that I was as a district attorney. We were able to achieve the goal of lowering our incarceration rates at our local jail. We were the only urban jail that constantly run a vacancy in the jail as we continue to lower crime. We were able to implement restorative justice programs, working with under 18 years of age, and actually seeing the results, touching and feeling the young people that actually did much better. We were able to work with the 18 to 25s and create a science-based young adult court. I am here because I'm back in my community, because I care, and I believe that we can go in a different direction. Thank you.
Thank you. First question is, in juvenile court, even though children have no right to a jury trial, they can still be charged with strikes under California's 3 strikes law. As you are aware, these strikes carry severe lifelong collateral consequences in future criminal cases, even if the juvenile records are sealed. Will you continue to pursue strikes against children in juvenile court if you're elected?
The answer is no. And one of the things that we did in San Francisco is that we, as we started to develop a restorative justice program for juveniles, we also looked for ways to ensure that young people under 18 were not being given a strike for the very reasons that a moderator mentioned. While it is true that a juvenile record is sealed, it is not sealed as to the consequences of a strike conviction that occurred before they were 18. So often what we see is that young people that are given a strike, sometimes for felonies that are generally not of a violent nature, they can end up having that strike come back and haunt them as they become an adult. There is no place in the juvenile system to use adult-level consequences, and certainly using strikes when you're dealing with juveniles. I believe it's both inappropriate and I think it's moral. Also, it doesn't follow the science. So I'm definitely against using that level of enhancement. I'm actually more in tune with using restorative justice models. We have seen that working much better. We get a better result. And if I were to be elected DA, that practice will be implemented here in LA County.
We absolutely need to move away from charging juveniles with strikes. And I just would like to take a second to explain what a strike really can be. Criminal threats, a crime of words, that can be a strike. That can label a child for the rest of their life. And you're right, without even a jury trial, without even the practice of having an open courtroom where the public can come in and see this is what's going on in our juvenile courts. We say that our juvenile practices are based on rehabilitation, on the fact that kids can change, the fact that kids should not be labeled at that young age, and yet we engage in practices like charging juveniles with strikes. And I have to say, we have to confront the fact that the majority are black and brown kids that are being charged with strikes. And this is a practice that we have to confront and we have to end, and that is what I would do as district attorney.
Thank you. What is your policy on criminalizing homelessness? how do you think the DA should deal with persons who are unhoused?
We need to stop criminalizing our houseless neighbors and instead look toward ways that we can end homelessness, that we can fight homelessness. One of the issues in our county is that everyone is pointing the finger at someone else and saying, well, this is your job to end homelessness. This is your job. Where's the federal funds? Where's the city funds? Where's the county funds? Everyone needs to work together in the county if we want to fight this problem. And that includes the district attorney. The district attorney has a role when criminalizing people who are homeless. That actually creates more homelessness. And what we've seen in our LA County jails over the last 10 years is a 41% increase in homeless people being incarcerated. So that means that the district attorney has played a role in increasing homelessness. As district attorney, I would scale back the incarceration of our homeless neighbors, and instead I would look to create a homelessness fraud task force to investigate big developers and corporate landlords that are engaging in illegal practices to illegally raise the rent and cause evictions and cause homelessness. We need a justice system that works for all. We need a justice system that calls illegality out. And we need a justice system that no longer seeks to incarcerate as the answer to homelessness.
One of the things that is often not discussed is that a lot of the people that end up in the criminal justice system that are also at the threshold of houselessness is mental health. And what this county has done for years is we have avoided the opportunity to intervene in a thoughtful and measured way. Recently, there was a study that says 6,000 people in our county jail qualify for mental health diversion, and yet we were sitting in our jail because our county district attorney has refused to provide that diversion. This is much like using a hammer to cure cancer. We're trying to cure mental health and substance abuse by caging people in concrete boxes and avoiding the opportunities to provide the right level of intervention, and one that is actually going to make us safer by ensuring that people are getting the services they need instead of caging them in a jail and having them come back over and over again. If I were to be elected DA, not only we would not be prosecuting these cases, but we would look at this as an opportunity to partner with many other organizations around the county to ensure that the people that need the services they need in order to get better will be provided. It is a fact that custody does not cure mental health, just like it is a fact that a hammer cannot get rid of cancer.
Mr. Gascon, do you support privatization of prisons, and why, if you do, and why not if you don't?
I absolutely don't. I have opposed the privatization of prisons and jails for many years now. I am pleased to report that actually in our state, now that practice would no longer go forward. Interestingly enough, as one of the co-authors of Prop 47, one of the major components of Prop 47 was a reduction in the prison population and actually allowing our prison system to be able to stop using private prisons in order to meet the federal guidelines that will be established by the judge. Prior to Prop 47, we were 180% of the population, and it was through Prop 47 and given an opportunity to people that have mental health issues and other people that could have been released and were released that actually we were able not to continue to have to use private prisons, and then legislation followed that now prohibits the practice. We have to ensure that through our practices we not encourage and make a business out of incarcerating our population. And when you have private prisons, you create a monetary incentive in order to incarcerate people. So private prisons is something that I have opposed for many years. I will continue to do so because I think that that is not the way that we want to run our criminal justice system.
I am absolutely against the privatization of prisons, and it is because once we privatize, there is an incentive to build prisons and there is an incentive to fill prisons. That's the way it works. But we need to look beyond the privatization of prisons. We've outlawed that in California for the most part, but we need to look at the privatization of the entire criminal justice process. We now have people moving toward the privatization of use of ankle monitors. of the rehabilitative programs that happen after you are on probation and you have requirements that you have to comply with these programs. As we continue to privatize all of the phases of the criminal justice system, that is how we perpetuate and we fill all of these phases of the criminal justice system. We have to take the incentive out, and that means removing and scaling back on this privatization in every single step of the process.
Ms. Rossi, what is your position on the death penalty?
We need to stop seeking the death penalty in LA County, and I'll tell you why. There are many reasons why. There are so many reasons why. Whether you believe in the death penalty or not, whether you believe in the power of the state to commit the death penalty or not, we just look at the racial disparities here in LA County, and that in and of itself is reason enough alone. When every single person sentenced to death row is a person of color, we know there's a problem there. And when we're looking at death, death is different. There is a finality that cannot be taken away. And that in and of itself in LA County is a reason to do away with the death penalty. Beyond that, we also see that the governor has issued a moratorium. Beyond that, our current district attorney has often relied on the fact that the voters have voted for the death penalty. Well, they haven't in LA County. And she needs to look at her constituents. There are multiple reasons why we need to stop seeking death in California, in LA County, and that's what I was doing as district attorney.
I have been opposed to the death penalty for many years. I actually campaigned in 2012 to abolish the death penalty in the state. As a district attorney in San Francisco for nearly 8 years, I never did a death penalty case. But here's the reasons why we need to take the death penalty off the books. Number one, science tells us today that the death penalty does not deter crime. And one of the reasons that the criminal justice exists is to make sure that we protect our communities by deterring crime, so we have a practice that does not deter crime. Number two, we know that the death penalty is terribly expensive, much more so than many other practices that we can. So we know that when we're applying the death penalty as it is applied in this county, we're breaking the bank. We're taking money away from dealing with violent crime and dealing with other things, and that's why violent crime in this county continues to go up because of the mismanagement of the current office. Number three, we know that the death penalty, as it's been applied in this county and in this country, has been very discriminatory. 22 people have been put in death row in this county since Ms. Lacy was the district attorney. All of them are people of color. Number four, you cannot reverse the death penalty. And we know that the criminal justice system makes mistakes. We have seen wrongful convictions. In fact, we have seen wrongful convictions in this county. We cannot afford to make a mistake with the death penalty. Those are the reasons why I'm opposed to the death penalty, and we will definitely not be seeking the death penalty from the beginning.
There's a question about reintegration and reentry, and that it's a critical component of an effective public policy. As DA, what would you do to ensure that people who are coming out of jail or prison receive services that they need to recapture their lives?
I think the issue of reentry is one that needs to start from the very first moment that you look at a case. When the DA is looking at the case, we need to look beyond the capacity to whether we're going to be able to get a conviction or not. We need to look, A, whether we should even try the case in the first place or file a case. Then, if we are moving forward with the case, we need to start looking at what kind of intervention are we going to provide. And then we need to project down the line, how would reentry take place? When I was a district attorney in San Francisco, we created the role of a sentencing planner. Those were social workers inside the DA's office, for the first time anywhere in the country, that actually worked with our prosecutors to evaluate each case before we even filed the case, to determine what was the final outcome that we wanted to have in the case. I was also the first prosecutor to go inside a prison at San Quentin and begin to work with the men that were there, and then later with women. We created a formerly incarcerated unit, advisory committee in my office that worked to assist people that were re-entering our community. And we actually worked with our jail to create a re-entry pod into San Francisco. If I were to be elected district attorney, this is the kind of practice that we would engage, because we need to look at re-entry not as people are coming out. We need to look at it from the very beginning of the process. Certainly for those people that are already in the system, we need to make sure that we facilitate their coming coming back home.
The number one single charge arrest for men in LA County is a violation of probation or parole. The number one arrest in LA County. So what that tells you is we can do a lot to put resources toward programs. We can do a lot to put resources toward drug and alcohol treatment. But if we are continuously locking people up when they make a mistake, we're not promoting reentry. Some of the things I would do as district attorney: never seek incarceration on technical violations. What's a technical violation? That's something that's not committing a new crime. That's a very minor violation, like failing to report that you moved. You should not incarcerate someone for failing to report their address when they moved. It is incredibly difficult after you've suffered a felony conviction to try and get back on your feet, especially if you've lost housing, especially if you've lost the custody of your kids. And now you have a felony conviction, and you have to find a job, and it's really, really hard to find a job. One of the things I would also do as district attorney is I would explore having district attorneys who are in training go through simulation processes of understanding what it's like to have the collateral consequences of a conviction. It's incredibly powerful when you file a case. Just the felony, not even getting to the incarceration, just the felony label on a person, that is a powerful, powerful tool that a prosecutor has. And I believe that each and every district attorney in our LA County District Attorney's Office needs to fully understand that impact. And that impact from the beginning of the case to someone's forever, the rest of their lives. And that's what I would implement.
Question for each of you. You seem to be making major shifts in your professional lives. Mr. Gascon, what led you to leave San Francisco and come to LA, and what's your experience within the LA DA's office?
As I mentioned earlier, I think if we have it about 3 inches. Sorry.
Is that good?
Can you hear me? No, I think
Like
we have
this.
to be closer.
Some are pointing. Some are high points too.
How about now? Is that any better? Can you hear right there? Seeing no's and yes. Hear me? Yes. Okay, I think
Yeah, that's good and pointing.
I think we have to get closer. As I indicated earlier, I grew up here. I spent most of my life here. A good portion of that I was with the LAPD. I went with the LAPD from being a patrol officer all the way to being the number 2 running operations. I learned about crime. I learned about the criminal justice system in LA County through my own personal experience, both as a young man growing up in this community, but also as a police officer. I was recruited to go to San Francisco to be the chief of police, and then when Kamala Harris became the Attorney General, I took her place as the district attorney and then got elected twice. When I announced that I was coming back home to come back with my family, many members of our community started to call me and ask if I would run for district attorney here, because they felt that the work that I had done in San Francisco, leading the criminal justice reform as a prosecutor nationwide and in the state, and many other works that I did, was something that they wanted to see in this county. And as I looked at my community and looked at my family, we made the decision that this was the right thing for us to do, because this is where family is, and this is where home is. I've spent most of my life here, and I believe that the criminal justice system in LA County is broken, needs to be reformed, and I believe that I have the capacity and the experience running large organizations, including one of the largest district attorney's offices in the country, as well as working in one of the largest police departments in the country, to come home and do the work that is needed to be done.
Ms. Rossi, you're a former public defender, federal public defender. What's the impetus behind your moving to the other side of the table?
So I have a very different background from anyone who has ever run for district attorney in LA County. And it's not just my public defender background. I was an LA County public defender, and then I was an LA federal public defender in LA's federal courts. And then I went to work in Washington, D.C., where I first worked on the Senate side with Senator Dick Durbin, and I was the lead counsel on the largest national criminal justice reform legislation that has passed and become law federally. Then I was recruited to work on the House Judiciary Committee, where I worked with Crime Subcommittee Karen Bass, Crime Subcommittee Chair Karen Bass, and worked on things like legislation that impacts women in the criminal justice system, legislation that affects reentry in LA County specifically, putting on hearings where we brought witnesses in and addressed the specific issues going on in LA County and across the country. I'm running because I'm excited about the idea of a district attorney who has not only seen the other side of the criminal justice system and brings that experience to every decision that she makes, but I'm also running because I have innovative ideas. I have bold ideas for reform that we can do right now in LA County, and I am the best candidate because I bring my experience, my humanity, my understanding of the system, and I am the candidate who has been in the courtroom litigating most recently, and I understand the many layers of criminal justice practices going on in LA County, federally and in the county.
Thank you. Question comes back to you. The next question is, how did you handle ICE raids and the separation of immigrant families facing deportation?
Our district attorney not only needs to not stand with ICE during ICE raids, our district attorney needs to take the extra step of standing with immigrants and protecting immigrants. One of the biggest problems in our immigrant community is a fear of being able to come forward as a victim, because then you could be deported. We need a district attorney that will ensure that ICE is not welcome in courtrooms and does not victimize victims further by deporting them. We need a district attorney that will also understand the immigration consequences whenever looking at plea deals in our courtrooms. We need to increase the access of immigration and crimmigration experts in the district attorney's office so that when we are filing cases and when we are considering dispositions on cases, we understand that a disposition that affects one person by just 5 days in jail and a disposition that affects another person, and that's 5 days in jail, deportation, loss from your family, never coming back, is not equal justice. We need a district attorney that will find ways to ensure that the law is applied equally, and that includes protecting immigrants who are in the criminal justice system, either as the accused or as the victim.
Yes.
You know, when it comes to immigration, as in almost every other part of our practice, I talk from both personal experience and I talk also from working in the system. In the San Francisco District Attorney's Office, we created training for our managers to make sure that our immigration cases or the cases that involve somebody that had immigration consequences, that we provided the pleas that entertain the consequences of their immigration status. When it became known that we had ICE going into some of our courthouses, in fact right here in Pasadena, we immediately created a system and provided safe passages for witnesses and victims that may fear immigration consequences when they were coming to the criminal justice system, either to be a witness or to provide testimony on somebody else's case or their own. We also went to Sacramento and actually worked on legislation that was signed by the governor that actually made it sure that all sides, both defense and prosecution, would never bring somebody's immigration status to the case unless it got approval by the judge ahead of time. And that immigration issue was one that was material to the case that we were doing. If I were to be elected DA, we will bring the same level of experience here. We are talking about the largest district attorney's office in the country. This is not a job for a trial lawyer. This is a job for someone that has run large organizations, and I'm the only one that has the level of experience.
What are the current budgetary problems facing the DA's office, and how would you solve those?
Some of the major problems is how the budget of the district attorney's office is allocated. What we've seen in the last few years is the increase in, for example, a division that specifically focuses on prosecuting people who commit crimes while they are in custody. That's an important focus, but so is diversion and reentry and restorative justice. So is mental health treatment. So is substance abuse treatment. These are the things that our district attorney's office is not putting resources toward, and instead we're seeing resources put toward things that are more punitive and more incarcerative, rather than looking at how can we actually rebuild communities? How can we actually take the resources and bring families together rather than just ratchet up penalties and incarcerate?
Yeah, the issue of the budget within the LA District Attorney's Office is one of appropriate distribution and the resources and whether you apply them. We have a district attorney today that has a history of mismanaging her budget across the board, has a history of applying a lot of the resources in areas that really make very little difference, and that's why violent crime continues to go up. At the same time that she spends an inordinate amount of time doing death penalty cases, or prosecuting juveniles as adults, or doing so many other things that really do not make our community safer. One of the things that I would do if I were elected DA, much like I did when I was a district attorney in San Francisco, is first of all create very clear and transferable accountability throughout the office, so we can account for every single person in the office, where they're spending their time, and whether that time is productive time in order to follow the goals of the organization, which is really to provide safety for the community, but do so in a way that is thoughtful, is sustainable, and makes sense. Trying cases is very expensive. Trying cases is often a resource that should not be used only unless it's absolutely necessary. This is an office that puts so much of a premium in fighting and trying cases that you have their deputies fighting cases and trying cases sometimes are unnecessary to be tried. Cases that should be diverted, cases that should go to mental health, cases that should go into other directions, whether they're juveniles or adults. So that would be the kind of work that I would make sure that we do.
Back to you, Ms. Rossi. Let's see, crucial to building public trust is accountability. How will you ensure accountability in officer-involved shootings and misconduct allegations?
I think we all agree there's a lot that needs to be done long-term. There are things that need to be done, including making the law less protective of law enforcement and working toward establishing a separate office that prosecutes law enforcement that isn't the DA's office. But I have ideas for what we can do today. So as district attorney, I would explore the use of appointing special prosecutors or independent prosecutors in the investigation and prosecution of law enforcement. What that means is we have a DA's office where district attorneys work alongside law enforcement every day. They depend on law enforcement for the gathering of evidence, for the provision of testimony in court, for getting their witnesses to court for them. They work very closely together. And then we ask the district attorney to turn around and prosecute law enforcement. That is an inherent conflict of interest. And we all know that we need to start to remedy that conflict of interest, but we need to do it today. We cannot wait. We need to take steps today to do that. And it is not an aspirational goal. I have 5 tangible ideas under current law as to how we can do this, and we can do it today.
We have recently put out a policy papers on our website that actually very clearly speaks to one of the broadest criminal justice reform efforts that would take place if I were to be elected district attorney. To begin with, we have to make sure that officers that are accused or have committed misconduct and that affects their credibility, they cannot be used as witnesses in any of our cases. That is one of the major problems that we have with the current district attorney's office. The second thing that we have to do is we have to make sure that we proactively investigate corruption within police departments or excessive force. As a district attorney in San Francisco, I've created the first of its kind independent investigation bureau that will staff with civil rights attorney to investigate police use of force and police shootings. I was also the first and only district attorney in the state that supported the legislation that would have reform use of force in the state. I was the only one that has come out and outspoken about the need to reform the law. We will, under my leadership, do 2 things. Immediately, creating an independent investigation bureau, which is one of the things that we can do as an interim solution. And that will be putting people in this role that are not involved in the day-to-day work with the prosecutors, much like we did in San Francisco. But more importantly, I will continue to do the work that I have been doing on the state level to ensure that we come to a place where we create a truly independent office that can do this work outside of the DA's office.
Would you describe the difference between restorative and punitive justice? and give an example of how you would change our current system if you believe it should be changed.
Absolutely. So when I was a district attorney in San Francisco, we created a program that we call Make It Right. And it's modeled after the community conferencing model of New Zealand, which is a full restorative justice model where you have a harm reduction approach to the way that we do the work. And we started that program with the under 18, the juvenile group. And basically, we started with a randomized group. So we had a control group that was going through the traditional process, and we had a group that was going through the restorative justice model, community conference, and we actually take attorneys out of the mix, and we give it to a nonprofit organization, the people that were trained to do this process. And what we found out is that when we put young people, and by the way, this was serious crimes, young people through the restorative justice model, the failure rate, or the reoffending rate was around 12%, whereas the kids that went through the traditional model was almost 40%. So we eliminated the control group about a year and a half ago and went straight to the restorative justice model. When you have a model like the one that is primarily used in LA County today, where you're punishing people as opposed to looking for ways to reducing the likelihood that they are going to stop reoffending and that they're not going to harm others, what you have is you have a repetitive process where crime goes up as it has in LA County, and where you never get to stop people from reoffending because our jails and our prisons are not places of rehabilitation. Generally, people will do worse when they get into those settings.
That's one of the biggest questions I get is, what is restorative justice? So punitive justice is the old model of what we sort of think of the criminal justice system in the past, just lock them up. Incarceration, that's the answer to solving crime, that's the answer to society's ills. What we now know is that restorative justice actually reduces crime and is effective at keeping communities safe. Restorative justice looks to what is the harm that created this scenario and what can we do to fix that harm. So in some situations that might mean a diversionary disposition. And that means, well, instead of locking this person up, I'm going to give them drug treatment because what led them to committing this crime was a substance use issue. Or in this situation, I'm going to give this person mental health treatment because what led to this offense was a mental health disorder and not something that locking someone up would actually cure. One of the big falsities that people who are opposed to reform will say is that progressive prosecutors are soft on crimes. Progressive prosecutors don't care about safety. Progressive prosecutors don't care about victims, and that could not be farther from the truth. When we look at the studies and the data, we find that longer terms of incarceration do not keep the public safe. Restorative justice does. And as district attorney, I would create a division of restorative justice and diversion in order to continue to expand access to diversion that exists and get access to new diversionary options.
Back to you, Ms. Rossi. Would you describe what performance standards that can be used to evaluate prosecutors?
So performance standards are currently what we have in our district attorney's office is an annual review where we look at this particular prosecutor, how many cases have you tried? How many convictions have you racked up? What's the worst crime that you locked someone away for? What's the longest amount of time you locked someone away for? And that is how promotions happen in the office. So that creates an incentive to go to trial, to lock people up, to get longer terms of imprisonment. What I would do as district attorney is shift the focus of what we're incentivizing for prosecutors to look at, are you actually reducing recidivism? Have you created diversionary dispositions that are creative, that actually have brought a family together and allowed someone to not go into prison and allowed someone to actually not commit a new crime? There are ways that we can start to evaluate when district attorneys look at a case and say, oh, this person has these immigration consequences, I'm going to create a creative disposition so we can move away from that. That's what I would do as district attorney.
Yeah, what we did in San Francisco is we began to look at increasingly at using more and more restoration and looking at diversion is that we started to move away from the traditional way the prosecutors are evaluated by the number of convictions, by the number of trials, which is very much the way that they are evaluated here. We also make sure that our training and our supervision is congruent with the goal that the role of the district attorney is not necessarily to try a case, but is to make sure that we get to the right level of intervention, whatever that is for a case. We created recidivism dashboards. We could see actually the different crimes in relation to the work that we were doing in the office and see whether our interventions actually were the most effective. That is the reason why we learned, for instance, that the restorative justice models gave us better results. And restorative justice model is much more than just simply diverting people. It's actually reducing the harm. You're bringing both the victim and you're bringing a person that has been accused. There is no contesting as to what occurred. Everybody agrees what has occurred. But then the conferencing takes place around how do we reduce the harm to the person that was harmed, and how do we work with the person that committed the offense, which is often someone that has been traumatized, and deal with their issues. And this is the kind of work that I did. We saw it in the day-to-day operation with the kids that we work with. We saw it with the young adults. We learn from this process that this is the kind of work that we would do here in life.
Thank you. With regard to mass incarceration, what would you do to reduce mass incarceration in LA County?
I'm glad that you asked that, because actually as a district attorney in San Francisco, we had researchers that came into our office to look at the level of work that we did. And they came to the conclusion that if we had every district attorney in the country incarcerated at the rate that we did there, we would end mass incarceration in a period of 2 years. We had the lowest prison commitment per capita of any office in the county, and yet we had a significant reduction in violent crime at the same time that we saw LA County numbers go up. If I were to be elected, we would be looking to do the same kind of work, where we're focusing on crime, we're focusing on the individuals, we're focusing on how to provide the right level of intervention, and we will make sure that we work with an understanding that sometimes custody time actually makes us more dangerous, not less dangerous, and we will reduce incarceration in the same way that I have done. We have a proven method of doing this work. We know that it works, and that will be the kind of work that I will be doing here.
So LA County is a very unique place, we all know, because it's the largest county in the country. And when we're talking about how we are the leaders of mass incarceration, when we are leading in incarcerating people, we can't just sit back and say, oh, well, I hope this problem gets fixed. We need to take active steps to look at the data, look at what we're doing, and implement reforms to start to reduce incarceration. We have to be proactive. One of the things I would do as district attorney is first start to track the data of what is going on in all of the different courthouses in all of LA County. We have courthouses in Compton, in Lancaster, in all over the county, and there are different practices going on that the public just isn't aware of. We don't know who is getting prosecuted more in West LA and getting prosecuted less in South LA. We don't know that data. We need to track that data, and then we can publish that data, and the public will bring outside scrutiny and will start to cause the reforms to happen. One of the things that I would also do as district attorney is look at ways that we can have a marked goal of how we reduce, how many filings, case filings we will reduce annually, and have the different offices look at who is reducing the case filings and who is not. When you have the offices looking at each other and looking at what is going on, that is when you start to reduce the rates of filing of cases. I would also create an Office of Diversion and Reentry that would focus on how can we start to reduce who is getting into the criminal justice system and who is getting locked up and who can instead go toward diversionary dispositions.
Domestic violence. Do you think that the district attorney has a role in stopping domestic violence? And if so, what do you think that role is?
Absolutely. I think that domestic violence is a very difficult type of case to charge. And that is often because it gets very complicated when a victim does not want to come forward and doesn't want to testify. And there are ways that our district attorney's office has failed the victims of domestic violence by refusing to pursue on those cases. There are also ways that I saw as a public defender where you may see a case where there's domestic violence and it is man on man, or it is or it is woman on man, and our office won't take those cases as seriously. We need a district attorney's office that will focus on domestic violence and understand from a gender-informed perspective, from a gender-diverse informed perspective, how we need to move toward models of understanding domestic violence today and understanding how to pursue cases so that all victims are accounted for, listened to, stood with, and placed at the front of the conversation. And I'll tell you very quickly, I had a client in our district attorney's office charged with domestic violence against her husband, and my client was being strangled in her kitchen in front of her kids when her husband was strangling her. She assaulted him in self-defense. And our district attorney's office didn't even look at that case, didn't even understand the complexities of that case, and filed against my client, a victim. We need a DA who is going to understand the implications of penalizing and victimizing victims.
When it comes to domestic violence, one of the things that is really important is that we look at a trauma-informed process. And that means that you have to begin to work with a survivor from day one, and that means that you have to ensure that the survivor's needs are attended to first and foremost. The prosecution may or may not be the appropriate journey for a particular survivor, but what we know is that something that is always appropriate is to ensure to begin by providing the services necessary. We also have to ensure that we are understanding of the nuances, both culturally, sometimes gender involved, whether you're dealing with an LGBTQ couple, whether you're dealing with people that may have maybe monolingual speakers of another language, so having the capacity to be able to work in a way that is culturally and trauma-informed is very critical. You have to ensure that the prosecutors and the investigators that are working on this case are people that are trained in doing this work. This is the kind of work that I'm accustomed to doing. This is the kind of work that is survivor-centered and family-centered first. Often, I had cases that we had to actually go to the school district and work with the school district because we knew that there were young kids that had witnessed an incident of domestic violence, and their performance in the school was being impacted. So the work has to be much broader than the incident that occurred that night or that day, but it has to be an approach that is completely understanding of the dynamics that go into a domestic violence incident, and you have to deal with high lethality cases as well.
Mr. Gascon, fines, fees, and bail can trap low-income individuals in a cycle of poverty and/or incarceration. How do you think fines, fees, and cash bail should be handled?
Well, first of all, we need to get rid of cash bail altogether. When it comes to pretrial, we need to really look at a presumption that someone should be released, and not because of the size of their pocketbook, but because of whether they are dangerous or not. As far as fees and the impediment that fees create, we have to ensure that we do not use fees and the warrants that often are attached to people when they fail to pay fees, whether it's because of some level of parking fees and citations that they got, or some other fees that they failed to pay. The criminal justice system cannot be used as a collection tool for people that cannot afford to pay these fees. We have to ensure that we don't criminalize the poor, which is often what we do when we go after people because they're unable to pay their fees. Certainly, we criminalize the poor when we ask for money bail, when we know that they're going to be held on pretrial detention, even though they may not be necessarily dangerous, or quite frankly, maybe not even have committed the crime that has been alleged. So we have to take the money out of the system, and we have to ensure that as the protectors of safety, that we are intervening at the right level for the right reasons in order to provide for community safety and not become the collectors of a system that is broken.
Start to abolish the fines and fees that criminalize poverty in LA County. Our County Board of Supervisors has started to do that in some limited cases to abolish the fines and fees, but we still have so many. And we still lock people up for failure to pay a fine or a fee. And I'll just tell you a quick example of a case that I had where if you plead guilty, your fines and fees in a case are much smaller than if you go to trial, because trial costs a lot. So my client actually went to trial, won, because the evidence was not there against her. And then she was hit with a fine of $1,500, plus penalties, plus assessments. And she couldn't pay that. She had to pay to show that she was innocent. So we need a DA who will stand up and say this is not right, who will fight for legislative reforms, who will fight at the County Board of Supervisors to continue to reduce fines and fees, and who will fight in her own office to reduce the use of fines and fees in her own office, because that still happens as well.
Two questions on legislation. The first has to do with AB 392. And the question is, what would you do to make sure that AB 392 is in fact implemented?
So AB 392 was the law that just recently passed that changed the standard for use of force in law enforcement. The law used to say that you could use force when reasonable, when other objectively reasonable officer would have also used force. And now the law says it has to be only when necessary. So a lot of people are concerned because that necessary isn't defined. And that means that whoever goes into court from our district attorney's office and who argues on the next case, whatever it may be, that person will be arguing what necessary means. That's why it's very crucial that we have an independent prosecutor in cases of law enforcement use of force, so that we have an independence of who is arguing in court for the most stringent definition possible. One of the things that happened through the negotiations in that bill was that we used to have a definition for necessary in prior versions of the bill. Our current district attorney opposed that, and she only then supported the bill when that was taken out. She wanted that ambiguity because she has wanted to stand with law enforcement. And so we need a DA who is going to stand up to law enforcement where it's necessary, and who will argue for a stringent definition for necessary, so that we can ensure that justice applies to all people in our county.
Part of the policy paper that we put together for law enforcement accountability, if I were to become a district attorney, is that we have to ensure that we have uniformity throughout the county, and that we go to not only using the minimum and necessary force, but that these terms are defined. We have approximately 55 law enforcement agencies in the county, and we have 55 different policies. The law as it currently is, it has been modified, and it is correct that we do not have a definition for what necessary is. A definition that actually was present on the prior bill, and I was the only district attorney that supported the prior bill. But having said that, that should not necessarily stop us from moving forward with the laws it currently is, and ensure that we provide the most robust and aggressive cases that we can. Furthermore, it is important that we have a county uniformity. If you go up to one part of the county, depending on the law enforcement agency, you can expect police officers to be guided by a policy that is very different in another part of the county. We should not ever have that kind of a problem. So there's two things that I would do. Number one, we have published a very clear policy that would address this issue. Secondly, we would take the current law as it is, and we would make sure that it's applied to the fullest extent that we can. And thirdly, I would continue to work with the state legislators to make sure that we get to a place where there is clarity around the law, and where force that is used is only the minimum necessary, and there is absolutely no other option.
Okay, what is your view of the Keep California Safe bill? And this is going to be, it looks like it's going to be on the November ballot. Do you have a position on it?
Is this the yellow law bill that is trying to unwind Prop 47? Yes. I'm against it. As one of the crafters, one of the original designers of Prop 47, there are several things that Prop 47 has really proven. Number one, we have now brought millions and millions of dollars, over $60 million to the LA County for rehabilitation services. And we have seen actually that we're reducing recidivism when we use that money. Number two, we have to ensure that we don't go back to the old form of prosecuting certain cases that are purely cases out of poverty as felonies. Prop 47 was very clear on what it did. Number one, it said drug addiction and and mental health are a health problem, they're not a criminal justice problem. And number two, it took certain low-level theft cases and made sure that they were given the attention that they needed, which is as a misdemeanor instead of a felony. We have to make sure that we do not go back to having companies like Walmart and others that are now pushing for unwinding a road that has shown very clearly that we're going in the right direction. There are many studies now that show that we have been able to actually do much better. LA County has been the recipient of over $60 million in the last few years and will continue to receive money in order to do the work that we need to do in order to intervene, to provide for mental health services, and to make sure that we move away from the addiction to incarceration.
The opponents of reform is that they don't base their arguments on fact. One of the things that I did when I was working in the House Judiciary Committee, the Crime Subcommittee, was plan a California field hearing where members of Congress came to California to learn from the state, to learn from our reforms, to say, what can the feds do now that we see that California is doing it right? One of the things that we did in that hearing was we called the experts and the witnesses who understood Prop 47 and understood the many reforms that have happened in California. And what the witnesses expressed was the data and the facts that show that Prop 47 cannot be tied to any increase in crime. That is the fact. So when people start to fearmonger and go out there and try and scale back the reforms, we have to look at the data, and the data shows that we have begun in California to safely decarcerate since 2010, since realignment. We have started to safely decarcerate in California, and we have reduced crime as a result. So I am opposed to all of the efforts that will likely be on the November ballot to scale back the reforms that are working in California.
Would you take to decrease the racial disparity in sentencing?
So we now know that there's racial disparities from every stage in the criminal justice process, from arrest to filing, to what charges are filed, to sentencing recommendations, and in post-conviction cases. So one of the things that I would do as district attorney is to start to track what my own office is doing, to start to track what is happening and what are the racial breakdowns on when we're filing enhancements, on when we're filing strikes. Where is the racial breakdown and what's going on? And then I would commission outside audits and oversight of my own office to look at ways that we can reform our policies so that we can stop the overcharging of the black and brown neighbors in our communities. We can't just sit back and hope that the data will shift. Right now in LA County, 80% of people in LA County jail are black and Latino. We can't just sit back and hope that that will go away. We have to take active steps to ensure that that is no longer who we are as LA County, and that's what I would do as district attorney.
How we take race out of the system is an area that is critically important in order to make sure that we continue to increase our road to reform and community safety. I use artificial intelligence to mask race and all the proxies for race out of police reports. When we take a look at the report and have the prosecutor make a decision before they knew what the race of the person was, and after they made that decision, then they could unmask and look at videos and other things to see whether they would still make the same original decision and lock all those decisions and make them available to researchers and transparently to the public. That is one step that we have to do. The other thing that we have to do is what Prop 47 actually was credited with, was one of the biggest reductors of disparity in the criminal justice system, because we knew that there were primarily people of color in our prison systems that were for offenses that were generally not impacting the white community. We need to continue to have the road of reform. We need to make sure that we regulate the way that the work comes into the district attorney's office, and we need to the extent that we can, we have to remove race and any proxy for race in the work that we do. We have a long road ahead, and certainly LA County is way behind many other places in this country, but that is not an excuse not to move forward. We have to make sure that we do everything that we can in order to reduce not only the effects of the implicit, but also explicit bias.
In many counties, counties, not only is the death penalty banned, but life imprisonment. Would you ban life imprisonment if you were in the district attorney's position?
Yeah, the answer is yes. I don't believe that life without the possibility of parole is an appropriate penalty anymore. One of the things that I did as a district attorney is that really as we learned and went through the science and looked at our work, we came to the decision that any penalty over 20 years needed executive level approval. And we found that by lowering our incarceration rate, again, we contributed to a better outcome for our work. I think there is a lot of science to it that would tell you that life without the possibility of parole is not only a problem for prosecutors, but it's also a problem inside the institutions, because people that go into prison without any hopes of getting out become a bigger problem inside the institution, and they never rehabilitate. So, much like the death penalty is outdated and needs to go away, so is the life without the possibility of parole. I would even add one other thing, is in this county, they have tried often, and they fought even the efforts to eliminate life without the possibility of parole for juveniles, which I think is immoral. So the reality is this is a practice that needs to go away. We have to look at every single piece of enhancement, especially those that are called status enhancements, which are based on what your prior history is, which is often based on who you are, where you grew up, and the type of policing that your community received. And we need to move to a more enlightened way. For every year in prison, study shows that you have a likelihood of reoffending between 4 and 7%. So you do the math, after 10 years, you're looking at a 40 to 70% recidivism rate, understanding 95% of the people that we touched are coming back out.
So the data shows that longer terms of imprisonment do not deter crime, and longer terms of imprisonment do not increase public safety. So we need to do away with the use of life without the ability of parole, and our current district attorney's office has overused this process for so long. And one of the things that people who advocate for life without parole don't fully understand is the difficulty that it takes to get out on parole. In our current system, our current DA has advocated to keep people in who have continuously tried to seek parole, and has seen her role in the parole process to be the one to say when this person who is seeking to get out on parole is lying. That's what she sees as her role in the parole revocation process. And what we need to do is to start to scale away from long prison terms that do not reduce crime, and to look at ways that we can slowly start to decarcerate not only in how many cases we filed, but in the length of the sentences that we're looking at. Two things. First, work with law enforcement. Second, stand up to law enforcement. And one of the things that our DA has failed to do is to engage in the conversation of what's going on with our sheriff's department. We need a DA who actually pursues justice for all. And that means that if there is injustice happening in our LA County jails with our LA County Sheriff, we need a DA who will speak to that, who will stand up against that. And our DA has been sitting silent. I do believe, however, that there is a way that our DA can work with law enforcement, can sit down with law enforcement, can talk about the issues with law enforcement, say that, look, we're not going to accept this anymore, you need to change your practices, and then if it doesn't happen, take action. Because a DA is supposed to pursue justice, not just justice for some, but justice for all, and our DA has not been doing that.
The role of the district attorney is to be the guardian of the entire system. By the state constitution, the district attorney is the chief law enforcement officer in any county in the state of California. Part of that role requires, A, that not only the district attorney holds himself or herself accountable, you have to start there, but you also have to hold other law enforcement agencies accountable, and the sheriff's office should be treated the same way that the LAPD or any other agency. We have to ensure that they do their work within the confines of the law, number one. Number two, there is a public safety role where we share responsibility, where the police and the district attorney have to work together, ensuring that we each do our work. And we have to ensure that the work is done lawfully, and it's done in a way that it makes sense to the values of our community. As a district attorney, you have a leadership role that clearly entails bringing police together and working with the police in a way that is productive, but you also have a role to ensure that that productivity and that work is done in a way that is lawful and is contextually appropriate for the current time in our community that we serve. And that's the kind of work that we do.
Following up on that, you both have indicated that some kind of independent civilian oversight of the law enforcement agencies is really necessary. However, there are over 50 law enforcement agencies in the county, so all of which require oversight. What is the role of the district attorney's office with regard to making sure that all of these various agencies, in fact, receive the necessary oversight?
Well, obviously, because each of these agencies works for a different city council, or certainly in the case of the sheriff department or for the board of supervisors, you're going to have differences from jurisdiction to jurisdiction. But where the role of the district attorney comes in, again, the district attorney is the guardian of the system. It is the obligation of the district attorney to ensure that every agency, in their practices, in their policies, in the way they conduct business day to day, that they're comporting with the law. And when they do so, it is the role of the district attorney to step up and ensure that when the laws are being broken, the law enforcement is treated the same way that we would treat any other person in the street. We have an obligation to make sure that we hold ourselves accountable. That includes the police. That, by the way, includes the district attorney's office. I think we have an office that often has prosecutors that are committing prosecutorial misconduct, and they're not being held accountable. So you have to start by cleaning up our own house. Then you have to make sure that you demand that law enforcement cleans up their own house. And when people don't, then you have to step in and do the work that you have to do. Now, in the cases where you do have civilian oversight boards, like you do with the LAPD, or you do in the case of the sheriff's department, then there will be another layer that you will work with in collaboration to make sure that we're all working together towards the same end.
The DA definitely needs to stand up when the law is broken, and it shouldn't matter what uniform you wear to work. If you break the law, you break the law. But in addition, there are some things that the DA needs to do right now when it comes to law enforcement, including sitting down with law enforcement when certain arrests are brought to the office and explaining why the DA will no longer prosecute certain charges. In addition, some of the things that the DA needs to do is expand its Brady release policy. So what that means is Brady is a Supreme Court case that says in any given case, if someone is accused of an offense, the prosecutor is required to give over all the discovery that could show that they might be innocent. And currently, our district attorney's office will provide discovery that is in their file, but the Constitution says you are required to provide any information that is in your file and in the hands of any law enforcement officer that worked on your behalf in bringing this case. I would revise the Brady discovery policy to ensure that every DA is going to law enforcement and making sure that they are getting all the exculpatory information and providing it to the defense, because that is one of the ways that we ensure the integrity of convictions. We want to be able to sleep at night knowing that when we file a case, that was a legitimate case. And one of the ways that we do that is by providing as much information as we can to the defense so that they can test that case, so that we can rely on it, and that we don't need to convict innocent people anymore.
So why don't we start with Mr. Gaston?
The LA County District Attorney's Office is the largest district attorney's office in the country. It has over 3,000 employees, and it works in a county of 10.5 million people. The job of the district attorney is one of leadership. It's an executive level job. It's a job where you're going to be running a large organization where you have budgets, you have personnel issues, you have policy issues, you have community issues, you have certainly political considerations, and you have the primary work, which is community safety. It is a job that requires a great deal of experience, not as a trial lawyer, but as an executive level person that has run large organizations. What I bring to the table is I bring many years of experience running large organizations, both police organizations and the district attorney's office. I have experience doing the work successfully. I have experience lowering crime and reducing incarceration. And my track record is one that is verifiable. There are two people in this race that have verifiable records. One is Jackie Lacey, and you know what her work looks like. And the other one is George Gaston. One of the best predictors of future performance is past performance.
Don't say that.
And I can tell you that by looking at the work that I have done, you can see very transparently how we reduce incarceration, how we improve public safety, how we work towards providing more accountability for law enforcement. That will be the kind of work that will be coming to light if I were to be elected district attorney.
He has it. He got the same track record.
We keep saying work with it. My people in the county, we keep saying work with it. Never once have I heard you guys say community. Not once. The thing that's wrong with civilian oversight boards is they don't have any subpoena power. So they need subpoena power. That's what they're lacking.
Vote for
That's
Measure
what
R, vote for
civilian
Measure
oversight.
R.
Community oversight.
So Measure R would bring subpoena power to the Civilian Oversight Commission, we need that, so everyone please vote for Measure R. I am running for district attorney as the first former public defender to run for DA in LA County.
How do you feel about LAPD being the most murderous police department in the nation? How do you feel about that?
The only candidate in this race who has the experience of running the largest prosecutorial office in this country is Jackie Lacey. And we see her record, and we see the terrible job she has done. I bring something to the table today, and that is fresh, innovative ideas and experience. I've worked in LA County courtrooms. I'm the only candidate in this race who's worked in federal courtrooms. I'm the only candidate in this race who has worked in the United States Senate and the United States House of Representatives on criminal justice reform. And when I did that, I sat down with law enforcement and with progressive criminal justice groups and was able to come to an agreement on criminal justice legislation that pursued safety and reform and decarceration. I have skills that other candidates in this race do not have, and I am running because I am the experienced candidate, and because I bring something to the table today, not in 10 years, not in 20 years, and not in 30 years.